70 ಮಾಡ್ಲಾ ಈಗ ಅದೇ ಬರ್ತಾರ ಬಿಡ್ತಾರ 70 ಮಾಡ್ತಾರೆ 70ನೇ ಇಡೋದು ನಮ್ಮ ಮಾಮೂಲಿ 64 ಇಲ್ಲ ಇದಷ್ಟು ವಿಡಿಯೋ ಪಾಪ್ ಆಗಿಲ್ಲಲ್ಲ ಸುಮ್ಮನೆ ಚೆಕ್ ಮಾಡ್ತೀನಿ ಇದ ಅದಲ್ಲ ಇದು ಹಿಂಗೆ ಮೂರು ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ ಕಾಣಿಸ್ತಿಲ್ಲ 1 2 3 ಇಷ್ಟಿಲ್ಲಲ್ವಾ ಇದನ್ನ ಹಿಂಗೆ ಹಂಗೆ ಬಿಟ್ರೆ ಅದು ಇವ್ರು ಬರಲ್ಲ 40% ಮೇಲೆ ಓವರ್ ಬರುತ್ತೆ ರೆಕಾರ್ಡಿಂಗ್ ಬೇಕು ಇದನ್ನೇ ಬೆನ್ನಿಗೆ ಮೀಟಿಂಗ್ ತಗೊಂಡೋಗಿತ್ತಲ್ಲ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಹೆಂಗಾದ್ರೂ ಒಂದೇ ಪೇಜ್ ಸೆಕೆಂಡ್
ಇನ್ನೊಂದು ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ ಮೇಡಮ್, ಅದಕ್ಕೆ ಕೊಟ್ರಲ್ ತರ್ಸಿ. ಎರಡು ಇತ್ತ ನೆನ್ನೆ. ಇದೇನೋ ಮೇಡಮ್ ಇನ್ನೊಂದೇನೋ ಕೊಡ್ತಾನೆ. ಈ ಮೇಲೆ ಕೆಳಗೆ ಮಾಡ್ಬಿಟ್ಟ. ಬೇಡ ಸಿಕ್ತು. ಅಲ್ಲ ಸರ್, ಯಾವ್ದು ಫೈಲಿಂಗ್ ಕೋರ್ಟ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ. ಯಾರೋ ಒಂದು ಪೇಪರ್ಸ್ ಕೇಳ್ತಾರಲ್ಲ, ಅದೊಂದು ಅವ್ರು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತಾರಲ್ಲ ಮೇಲೆ ಹಿಂಗೆ ಹಾಕೊಂಡ.
Yes.
Serial number 1, Maya Valla.
I will not take more than 5 minutes. I have made my submissions. just I have made a small compilation. It's same thing, but I, instead of searching for all documents, it is in one compilation.
At the end of the day, we will have boxes of papers.
Nothing new in that, my lord. Only the rules and everything in one document it will be available. My lord, these 4 rounds, it is not available in rules. It is by judicial precedents. Lord, there is no dispute after first and second round, these people will not have right to participate in the consequential seats. This issue, similar issue has come to the consideration before the Honorable Supreme Court in Bhavna Tiwari. Lord, one specific direction I would like to point out from Bhavna Tiwari, your Lordship may kindly have a look at page 63 of the bunch which I have given now. Lord, only 5 documents I have given, Lord. In that, 2 sets of rules also I have provided. Lord, page 63, your Lordship, last paragraph, paragraph 16. As held by us in paragraph 14.4, we issue the following direction to the concerned authorities. I'll skip 1, 2, 3. 4th paragraph, your Lordship. Permit upgrade windows post round 2 for admitted candidates to shift to better seats without reopening counsel to new entrants. Here, Lord, if we apply these directions to the facts of this case, Lord, these new seats which is added in between the second and third round was not available on the first date. My submission is, Lord, these 443 will have to be treated as the seats available on the first day when we participated in the counseling. They should not have allowed new entrant to participate for these 443 seats. Only when we exercise this upgradation as per this direction, then Lord, these seats will fall as a vacant seat for consequential round. Therefore, because they allowed registration of new entrants for these 443, this anomaly has taken place. That is what, Lord, the division bench has considered in para 38. The Justice Banerjee has taken a view. Kindly have a look at that para. Page number 70. Para 38. Yes. Lord, Justice Banerjee's view, after referring to Bhavna Tiwari, para 37 and 38. Lordship got it?
Yes, sir.
May I read para 37 and 38?
Yes, sir.
Not para 37.
Yes, sir.
However,
Just a minute. Just a minute.
yes,
Yes, sir.
however, the Supreme Court has been pleased to grant such relief and pass such orders from time to time in various judgments, and orders some of which are noted above, due to which the process of seat allotment in medical colleges is being carried in smoothly all over India. Therefore, the direction given by the Supreme Court in Bhavna Tiwari that upgrade windows post round 2 for admitted candidates to shift to better seats has to be permitted without reopening counseling to new entrants is the mandate that the respondents are bound to comply. Therefore, new registration for the first stage of third round of counseling for the 443 new seats could not have been made by KEA. Only the admitted candidates post second round of counseling would be entitled to participate in the first stage of third round of counseling. The third round of provisional seat allotments list of candidates dated 24/10/25 is therefore set aside, with the direction to the KEA to undertake the process of third round of counseling afresh, strictly as per the direction of the Supreme Court in Bhavna.
In 2 stages.
Yes,
The operative portion says in 2 stages.
yes, because Lord, there are 4 rounds. Admittedly, there are 4 rounds now. Now, as per Bhavna Tiwari, another round is added, which is they call it as upgrading round. After second round and before third round, in between, for upgradation of these people.
See, First, you have graduate medical education regulations.
Yes.
Then you have Karnataka selection of candidates for admission to government seats in professional educational institutions.
Yes.
Now, combined reading of both these regulations give ample room to KEA to frame their own procedure for
Yes, ma'am.
no qualms with regarding that. Now, some places it is 3 rounds, in some places it is 2 rounds.
Yes, ma'am.
In our state, it is 2 rounds, normal thing. The 2 rounds thing, not for 443 seats, but the regular 2 round thing, you are not challenged.
Yes.
The regular 2 round thing, you are not challenged
We are not.
in your writ petition.
Yes, ma'am.
The problem comes in because of the infusion of 443.
For-
Now, for 443 also, if they had done the 2+ and then the mop-up, usually would not have any grievance. But 443, what they do is they do only 1 round.
Yes.
443, they do only 1 round. Then you have this, the 3rd round coming in.
My lord, my submission is
Ah.
these 4 rounds, these round 1, 2, 3, 4. Several judicial decisions, my lord, Bhavana Tiwari have not read full. My lord, if your lordship could see the judgment.
Bhavana Tiwari
Yes, my lord.
analyzed the existing modality in the state of UP.
It is not only UP, my lord. It is not only UP. They refer to all the earlier judgment of the Supreme Court.
Correct. But it pertains to more of
In a similar situation. In a similar situation. There also, my lord, kindly have a look at first paragraph, that para number 2 and 3. ಸ್ವಲ್ಪ facts ತಾವು ನೋಡಿದ್ರೆ it will clarify the things. Situation where, my lord, the lower ranked candidates got a better seat and higher ranked candidates, they did not get their choice.
now, supposing there was no infusion in 443, then in that event,
We have no claim.
see at the end of round 2,
Yes.
at the end of round 2, if you see, you have to make a choice whether to give up the block seat and then come up for the mop-up round,
Yes.
or exercise your choice.
Correct.
Okay.
Correct.
You have to take a decision.
Yes.
Now, supposing you take a decision not to give up the block seat, still there could have been a chance in the mop-up round where you would have got a better seat.
Yes.
You exercise your choice over there.
But I am not supposed to, because my right ends with ground.
Yes, proceed. Yes, next.
As far as Lords, the 443 seats are concerned, I was Lords permitted to participate. And on that, Lords, I don't have a grievance. Now, Lords, whether Bhavana Tiwari applies, whether Lords had been treated as Lords a separate round, all that Lords, ultimately Lords arguments have been made. My other grievance, Lords, is with regard to Lords that the vacancies that arose as a result of Lords people exercising Lords the choice in the 443 itself, which Lords, according to them, is Lords approximately about 184 seats. Now, Lords, in respect to these 184 seats, it Lords again is pushed Lords into that second bracket, not Lords or me. And the strange thing, Lords, is that this consequential allotment or consequential vacancy, that is, Lords, which arose, Lords, in the process of the seat allotment itself. In Lords, every other round, they have Lords permitted those to be filled up in that very round itself. I just Lords point out, in fact, Lords, the second round, the notification that they issued, Lords, for the second round, that Lords would find in their statement of objections, Lords, at page 16, Lords, in Lords WP 31934. Of Lords 20th August, Lords, page 16. 20th August. I'll not straight away just take Lords to page 17, Lords. These were read out, Lords, the instructions that Lords would find at the bottom, Lords, of page 17. Sorry, page 16. I'll just straight away request Lords look at Lords point number 6, Lords, in this at page 17. Candidates can change or remove higher order options In the second round of seat allotment process, the seats arising due to candidates taking up other seats are also allotted on merit basis. So that the candidates can retain their seats even if there is no availability of seats in the seat matrix. Candidates are advised to mention all the seats they are interested in order of priority. Then notes the note, that is notes after point number 7, also notes assumes importance. Note, consequential vacancies that arise during the allotment after the candidate merit or turn cannot be claimed. So the corollary to this would be that notes until his turn, if notes there are any vacancies that arise, in consonance with Milord's point number 6, that candidate Milords is entitled to choose. It is only Milords after his turn is over. Milords. Ultimately, everybody gets a turn Milords based on their merit. Two Milords choose whatever are the vacancies or the vacancies based on Milords their priority or choices or whatever one may call that. So until Milords it is his turn. If Milords there are vacancies that arise, they are Milords entitled. If a vacancy has arisen after this candidate is given that choice, what this says is that is not available. So therefore, the consequential vacancies that arose in a round were in the second round, it was permitted to be filled up in that round itself. Now, strangely, when it comes to this round, the third round, when it comes to these 443 seats, that option is not given to the candidates who had seats in the first two rounds. It is given only to the other candidates whom
So you're saying there's an arbitrariness because
Please,
in the second round, before infusion, the seats which fell vacant with others on top exercising their option, they were made available for you.
Please.
That should have been there even
in the third round,
even in the infused seats.
Please,
and that not giving you that benefit is arbitrary.
Please,
because it would be in consonance with what was offered in the second.
Please, which is their own procedure that they followed earlier. And the other thing, is also this: when it comes to every other category of seats, engineering, architecture, the Indian systems of medicine. The third round has this consequential vacancy being allotted to everybody. I have produced that at page 233 of my petition.
That's
31934.
Page number, sir?
This is page number 233, 233.
Just
Annexure AL2. Annexure?
This is annexure AE, at page 233.
yes, sir. Eligibility.
This is what this is 6925. This is UGC 2025 third round seat allotment for engineering, architecture, veterinary, agricultural science, pharmacy, BSc nursing, yoga, naturopathy, BPT, BPO, allied health sciences, etc., including UG Ayush courses. So it's for everything other than dental and medical. So there, B at page 233 is the instructions to all categories of candidates regarding entry of options for the third round of seat allotment. There, point number 3, Further, seats will be considered for allotment as a result of any consequential vacancy that may arise during the seat allotment. So, again, when it comes to every other category of seats other than medicine, they say, well, if there is a vacancy that arises in the seat allotment process, we will fill it up in that round itself.
So that was also extended, made available for the second round.
That is also for the second round. This is I'm saying in the same third round. What happens is every round.
We are examining all questions only because of infusion and the procedure that is followed.
Please.
Right.
So I'm only saying that this
your cases, if second round permitted consequential vacancies, the round after infusion for those infused seats should also have permitted consequential vacancies. But after you chose, you are exited,
I was,
and whatever was consequential vacancy have been offered to the new entrants, and the others, therefore, though less meritorious, they take better seats. That's the case. So that's the addition. That's another aspect that you point out to what Madam is pointing out.
Yes. But 1.4, the WP number 32519. Facts rest on the same issues.
Just a minute.
Yes.
See, the point is, it's coming A3 first.
Consequential is intermediate vacancies and intermediately in the 443 are actually. Yes.
There's a little buffering that is
Yes.
taken. So give us a second.
Yes. More on the facts, facts are, we are all in the same situation, where ultimately less meritorious ended up in getting these 443 seats.
Now, there are twofold submissions. One, according to Madam Vidyulata, even the consequential seats should have been offered along with
Yes.
the infused seats. That is first fold. The second fold, and she's supported by Mr. Nayak, Mr. Vivek, is they could not have been exited after the first part of the
That is
counseling,
precisely what we are.
first part of the counseling
Yes.
for the casual vacancies.
Yes.
That's the, there they
That-
say
Yes.
it is arbitrary,
Yes.
firstly on the ground that it is discriminatory.
Yes.
Secondly, as Mr. Nayak was, Mr. Vivek was pointing out,
Yes.
this is a choice that is available in the second round.
Correct.
This is a choice that is available in the other streams
Yes.
or disciplines,
Yes.
even for the third round. Therefore, there is no reason to exclude.
Yes.
That's Mr. Nayak says upgradation is part of, is something that they are entitled to
Yes.
in terms of the Supreme Court's directions before the new entrants are permitted to. Correct, Mr. Nayak?
Correct.
So these are essentially the threefold arguments that are present.
But on the question of discrimination and equality, there will be only one issue. There should be a level playing field. Whatever may be the rules or whatever may be the intermediate arrangements they make in view of the influx of a 443 seats. Assuming 443 seats came, they now have to distribute it. Whatever they do must have a level playing field. And it should have a semblance of
Is it
equality.
level playing field or primacy to merit? Because
Huh?
because
Yes, a primacy of merit. But level playing field, by that I mean, there must be primacy of merit. That is what ultimately it should answer that test. And if it answers that test, then it is fine. But
Does
it
it
should
or-
not result in a situation.
does it or does it not?
It does not.
Why
It
would
does
you
not.
say?
Because ultimately, all of these petitioners, we have the chart, all of these petitioners have lost the 443 seats to persons with lesser merit and lesser
We
rank.
don't know how Mr. Ramesh would meet all these submissions, subject to that caveat.
Yes.
If we were to ask you, sir, that one of the, to ensure that merit prevails, they have devised the options being identified for once,
Correct.
and that identification of options is made sacrosanct, because that will decide, that will
Perfect.
be the rule.
There is no
defined-
human interference.
That is the game defining rule. And so long as we stick to it and everything else is worked around that to meet certain exigent circumstances, there's no arbitrariness could be one, because Mr. Ramesh has been emphasizing when in the initial opening round, as we would call it before us, that we give them the option of making their choice. Once they choose, that is frozen.
Yes,
And within that choice, all the options are thrown out
yes,
in the first round, in the second round. So some seats may arise, some seats which are more beneficial may arise. But if they are not part of your options, or we will not use the word choice because choice is another.
but all this amounts to, all this zeroes down on how they have made the software. Ultimately, human beings make this software. And if they have arranged the software, it is a pre-built software, which they're using for this new situation of 443 seats. So what they ought to have done, my humble submission is, because I watched their arguments before the previous bench, what they ought to have done was, this 443 should have been taken with the old contestants, the old persons who have participated in the first two rounds. Even though it was a third round, etymologically or in common parlance,
It is not effectively a third round, it is a first round.
It is a first round. Because they brought in these seats, they should have limited the contestants or the applicants to those persons who were already in the race, exhausted this, rerun the first and second round or only one round for this, and then moved on, taken the balance seats to the
Treatment.
yes.
With senior company.
And then in that process, when that was brought, they have taken us for one round and we have been ejected.
That's what
exit. That exit is the area where even they cannot control nor we cannot control because of the pre-built software.
Now that
How
is
the
why,
software is
that is why we are asking if they have as a consistent adherence to the rule that you choose and we let you go by that choice alone. How do we say there is?
But then what would,
Because what something could have opened up,
yes,
but it may not be within the zone of your choice.
yes, Lord, what would happen is
Or
this.
your
I
option.
understand what your lordships are pointing out. What would happen is this: a software is already made and it is with them. We are not concerned about that. Point is, when a new situation or a circumstance arises, the way they address that situation is the only issue here. And what they have done, they should have allowed this fray to continue, this competition to continue with the existing participants, and taken the balance that is there in the 443 into the mop-up. They should have treated that's a clean definition, and
So they have not done is a fact.
is a fact.
They have not done is a fact. Now, the legal argument by your younger friends is that legal arguments by your younger friends are it's arbitrary.
Yes.
Well, these are new seats for all purposes. If they permitted casual vacancies in the second round, they should have permitted casual vacancies even in this round before locking out
Yes.
the others.
Yes.
Essentially, and of course, Mr. Nayak.
That is all we are trying. And that arbitrariness is because they did not adopt. They should have taken it as two segregated fields and first finished this 443 with the old method and then gone on to an overall mop-up with the 440. That they did not do, which is not created the level.
Let us hear how they defend. Mr. Sauri may not have anything to say. Nothing on that. So you nominate KEA and you admit that they have the elbow room. They have the elbow room to adapt to an emerging situation.
And one
In the new regime, we only nominate them, Lordship, they act.
And they have the elbow room to adapt to emerging situations subject to merit.
Now, Lord, one last submission of mine is, due to the KEA mixing the mop with this 443, what has happened is, this is practically what has happened. The mop-up considerations and choices, which the computer took, and the 443 choices which it took from the old participants who are about to leave the existing places for these 443. By combination of all this fault has occurred. Because perhaps the software has treated them as one, but we human beings are treating it as two. But the software has treated them all as one and given the result. So this they should not have done. That is where they are lacking in.
They have
in their
not done
approach.
is a fact.
They
Whether
have
there
done
is-
is a fact.
Whether there
They
is,
have done
a-
is a fact.
whether there is a cause,
Ultimately, Lord,
no, whether there is a cause, whether that cause can be entertained
yes,
at this stage.
yes.
Of course, Mr. Nayak says it's only a initial list, not
It's
the
only an
final
initial
list.
Yes.
We will consider subject to.
Yes.
Yeah.
And still there could be permutations. If we allow this list to run today, still there could be permutations where people will leave this round and join further. So therefore, it is retrievable. We can address this situation, ensure proper ranking, and then proceed. Please. It should be taken to its logic.
Yes, sir. Now,
Oblige.
we will also consider that though this is a provisional list, not the final list, those who stand to benefit are not before us in the present proceedings. Are not before us.
But Lord, there is a stay and they are aware that the proceedings are pending. Since about 3 weeks or 4 weeks at least, 1 month at least, they should have come now and try to address their grievances if any.
Well,
And it's only a provisional list.
we'll definitely consider that.
And
That
it
is also
is
something-
perhaps since it is provisional, they are also waiting for it to take shape, final shape.
Yes, yes, Mr. Ramesh. Now, all others versus you as it emerges, sir.
Lord, here, first thing what I say is, Lord, the facts are not in dispute. These are the students who have entered first round and choice two. Choice two, that also we have given, that benefit also they have reaped. Then, my Lord, we have our regulation, rules. Rules, my Lord, your Lordships have already seen, my Lord, that the notification, first and foremost, my Lord, my friends were saying there is nothing was published. All that, my Lord, your Lordship may kindly take, my Lord, this thing which everything is available in this, all our notifications. Spiral bound.
Second.
Oh, I'm sorry. I made a synopsis of arguments. I'll just try.
Yes,
Your Lordship, kindly take, my Lord, the spiral binding. There, your Lordship, may kindly take page 69. We have as many as 3, my Lord, brochures were published. Page 69
you call it bulletin
of the brochure, got it.
69.
Of the spiral bound, my Lord.
Yes, 69.
Then, my Lord, this is the notification by the NMC under which, my Lord, we
The
operate.
nominee.
Then down below, your Lordship, online seat allotment. Information about the online seat allotment along with instructions, procedures, guidelines and schedule for each round will be published in the letter in KEA website. So, my Lord, because these are all procedural laws, it goes on changing, my Lord. Therefore, my Lord,
So up to second round, no conflict,
no conflict, no conflict. Yes.
right, sir? Now the area of difference comes about, or the reason for the present cause comes with the infusion
Yes.
and the method you have adopted.
Yes. Your Lordship.
According to them, there are to defining effects.
Yes, I'm
One,
coming
we
to
are
that.
not on the, we are not on the consequential seats.
Yes, sir.
We'll call it the casual seats.
Yes, sir. I'm coming
You
to that.
offered vacant, you offered the infused seat only once.
Yes. Now, Your
Then
Lordship,
you exited them.
exited them by operation of law, they get exited.
Which law?
Law in the sense, not the brochure, notifications.
Which part of the brochure?
That, Your Lordship, I can take page 135 of the same paper.
Yes, sir, 135.
Well, when they entered the second round,
Hmm.
well, this one, after enabling the option entry, third, item 3, instructions for entering the options, that there is a consent. They have to click that. They are agreeing for all the conditions